Welcome back to the deep dive. Today, we're taking a close look at an area of contract law that deals with some real curveballs, the unexpected things that can completely derail an agreement.
Right.
Contracts are usually pretty straightforward, aren't they? They just end when everyone does what they agreed.
That's the
Performance.
standard path, yeah.
But what happens when something totally outside anyone's control just, well, blows up the whole deal?
Well, that's where we get into the doctrine of discharge by frustration. It's what we turn to when a contract simply can't be performed or performing it becomes something radically different, all because of some unforeseen event.
Okay.
And our goal today, using the materials provided, isn't just to define it. We really want to walk you through how you actually use this idea to analyze a problem. Think of it like working through a guided study session, breaking down a legal scenario step by step.
All right, let's get into it then. So, at its heart, what exactly is frustration according to these materials?
Well, the definition they give is pretty precise. Frustration happens when, after the contract's made, some kind of supervening event occurs.
Supervening, meaning it happens later.
Exactly,
Um,
after signing. And crucially, this event can't be caused by either party, it can't be their fault, and it generally shouldn't have been foreseeable.
okay.
And the effect, it makes performing the contract impossible or transforms the obligation into something just fundamentally different from what everyone signed up for.
So, it's got to be a really major change. It's not just, say, becoming inconvenient or more expensive.
No, exactly. That's a key point that the materials stress. Just finding it harder or costlier to perform, that's rarely frustration. The change has to hit the very root of the contract, sort of destroying its commercial purpose or making it something else entirely.
Right, like if market prices shift and suddenly your profit margin shrinks, that's just bad luck, not frustration.
Generally, yes. That's considered a business risk you take on. Frustration requires something much more fundamental.
Got it. So, what kinds of events do qualify? What have courts typically recognized? The materials list a few main categories with some classic cases.
Yeah, they outlined about four main types. The
Mm.
first one is probably the easiest to grasp: destruction of the subject matter.
You mean if the actual thing the contract is about literally gets destroyed?
Precisely. Think of the classic case, Taylor and Caldwell. They had a contract to rent out a music hall for concerts.
Okay.
Before the concerts could happen, the hall accidentally burned down. Poof,
Mm.
gone.
Ah,
The court said the contract was frustrated. Why? Because the essential thing needed for performance, that specific music hall didn't exist anymore. Performing the contract as agreed was literally impossible.
makes sense. Can't hold a concert in a pile of ashes. Okay, what about when the thing is still there, but the whole reason for the contract disappears?
Good question. That leads us to the second category: non-occurrence of an essential event.
An event that was crucial.
Yes, the very foundation of the contract. The famous examples are the coronation cases, like Crowe and Henry. Someone rented a room specifically to watch King Edward VII's coronation procession.
Right, I remember reading about that.
But then the king got sick, and the procession was canceled. The room was still there, perfectly fine, but the court found the contract was frustrated because the entire purpose, the whole point of renting that room at that time, viewing the procession, had vanished.
So even though you could technically still use the room, the fundamental reason for the contract was gone.
Exactly. The shared purpose was tied directly to that event happening. Okay, moving on. Government actions can also be a big one. That's the third category. Government interference.
Like if the government suddenly passes a new law or regulation that stops you?
Precisely that. The materials mention Lim Kim Som and Sharifa Taiba. There was a contract to sell land. But before the deal could be legally completed, the government stepped in and compulsorily acquired part of that very land. That government action made performing the original sale contract, as agreed, impossible.
Right.
Frustration.
Right. And the last one, what about people?
Yes. Personal incapacity.
Yeah.
This applies mainly to contracts for personal services where who performs is critical. If that specific person dies or becomes seriously ill or incapacitated, the contract might be frustrated.
So if you hire a specific artist or performer?
Exactly. The case example is Condor and the Baron Knights. A drummer was hired, contracted to play with the band 7 nights a week. That was the deal.
Mm-hmm.
He then became ill, and doctors advised he could only safely play 4 nights a week. The court held the contract was frustrated because his required service playing 7 nights, which was essential, became impossible due to his illness.
So the specific performance required couldn't happen. Okay, that covers the main types. Destruction, the key event not happening, government action, and personal incapacity. These are the big shocks. But it's just as vital to know when it's not frustration, right? The
Right.
materials mention some key exceptions.
Knowing the limits is crucial. First big one, foreseeability.
Meaning, if you should have seen it coming.
Broadly, yes. If the event that happens was something the parties could or should have reasonably foreseen when they made the contract, courts are much less likely to call it frustration.
The idea being you could have planned for it in the contract.
Sort of, yes. Or at least you accepted the risk. The key case here is Davis and Ferrum.
Wasn't that the building contract one where things got really difficult?
Exactly. Building a housing estate took much longer and cost way more than expected, mainly because of shortages of labor and materials.
Okay.
But the court said, nope, not frustration. Why? Because those kinds of shortages, while maybe worse than anticipated, were considered foreseeable risks in a large construction project back then. It made the job harder, more onerous, but not radically different or impossible in the way the doctrine requires.
So there's a line between this is harder than I thought and this is now impossible or illegal.
A crucial line. Foreseeable difficulties usually don't cut it. But an unforeseen event that makes performance actually illegal or genuinely impossible, that's different territory.
Okay, that distinction is important. What's the second barrier to claiming frustration?
That comes down to the contract itself, force majeure clauses.
Ah, those clauses you see sometimes that list things like acts of God or war.
Exactly. Parties often put these clauses in specifically to anticipate certain kinds of disruptive events, maybe natural disasters, strikes, specific government actions, whatever they agree on.
Mm-hmm.
If an event occurs and it falls squarely within the scope of a well-drafted force majeure clause in your contract, then that clause takes over. The rules of frustration step aside.
So the contract's own solution applies first.
If it covers the situation, yes. The materials mention China Resources and Magenta Resources. There was a contract to sell urea, and it had a force majeure clause. Political problems cropped up, preventing shipment and getting a needed certificate.
And the clause covered it.
The court found it did. So the clause, not the general doctrine of frustration, dictated the outcome, excusing the seller. The exact wording of these clauses is absolutely critical, though.
Right, precision matters. Okay, and the third big exclusion.
This one's about fault. Self-induced frustration.
Meaning you can't cause the problem yourself and then try to use it as an escape hatch.
Precisely. If the event that makes performance impossible or radically different is actually due to your own actions, your own choices, or your own default, well, you can't then claim the contract is frustrated. It's your own doing.
Makes sense. What's the case for that?
Maritime National and ocean trawlers. A company chartered several trawlers, but they needed licenses to operate them. They were allocated fewer licenses than they needed for all the boats they chartered.
Okay.
They chose which boats got the licenses, leaving one without. They then tried to claim the charter for that boat was frustrated because it couldn't legally fish.
But it was their choice of which boat didn't get the license.
Exactly. The court said this wasn't frustration, it was self-induced. Their own decision created the impossibility for that specific charter.
Okay, so foreseeability, force majeure clauses, and not causing it yourself, those are the main hurdles. Now, let's say a contract is properly frustrated. What happens then? Legally, what are the effects?
Well, the big consequence is that the contract is automatically discharged the moment the frustrating event happens. It just ends.
Instantly?
Yes, from that point forward. No more future obligations. Now, under the old common law rules, the outcome could be quite harsh, basically. Losses just stayed where they fell at that moment.
So if you'd paid money up front, you might just lose it.
Potentially, yes. But, as the materials point out, many places now have legislation, like the Frustrated Contracts Act, to deal with this more fairly.
Ah, so the law provides a better way to sort out the finances.
Exactly. These statutes typically give courts the power to make adjustments. They can allow someone to recover money they've already paid or stop them from having to pay money that was due. They might allow recovery for expenses incurred preparing to perform or compensation for benefits someone received before the contract ended.
So it tries to achieve a fair outcome based on what actually happened before the frustration.
That's the goal, yes. A more equitable distribution of the losses and gains.
Okay, fantastic. We've built up a really solid picture now. What frustration is, what causes it, what stops it, and what happens afterwards. Now, for the really practical part, applying it, the materials give us this hypothetical scenario.
Right, this is where we put the theory into practice, almost like tackling a problem question you'd get in a tutorial or exam.
Okay, so the scenario is a company books a specific conference hall for a big international summit planned for next year. But then, 6 months before the event, the government passes new legislation. This law specifically makes large international gatherings of that type illegal, citing public health reasons.
Mhm.
The big question is the contract for hiring that hall now discharged by frustration?
Okay, so how do we approach this systematically? The guide suggests using that classic structure, issue, rule, application, conclusion, often called IREC.
Right. Let's do it. First step, issue. What's the core legal question?
Pretty straightforward here, isn't it? So,
Thanks.
is the contract between the company and the hall owner for the hire of the conference hall discharged by frustration due to the new legislation?
Yep. Got it. Nail the question. Next, rule. This is where we lay out the relevant law we've just been discussing, but focusing on what applies here.
Exactly. We'd start by defining frustration. Again, supervening event, outside control fault, not foreseen, makes performance impossible or radically different.
Okay.
Then, critically, we identify which category this looks like. Here, it seems pretty clearly like potential government interference, right? So we'd cite a case like Lim Kim Som as an analogy where legislation caused frustration.
And we also need to bring in the potential roadblocks, the exceptions.
Absolutely. You have to anticipate the counter-arguments. So would you state the rule on foreseeability, maybe mentioning Davis and Ferrum, to highlight the difference between mere difficulty and true impossibility illegality? We mentioned the potential effect of a force majeure clause, noting whether the scenario mentions one or not, perhaps referencing China resources. And we state the rule about self-induced frustration, citing Maritime National.
And briefly mention the effect. If it is frustration, automatic discharge, Frustrated Contracts Act applies.
Yes, just lay out the complete legal toolkit relevant to this problem.
Okay, rule section done. Now the crucial part, application. This is where we connect those rules to the specific facts of our summit scenario. It's the real analysis.
Let's break it down. What's the supervening event?
That new law passed 6 months before the summit, banning this exact type of gathering.
Okay. Is that event outside the control or fault of the company or the hall owner?
Yes, definitely. Neither of them made the government pass that law. It's external.
Now the tricky bit. Does it make performance impossible or radically different?
Well, this is interesting. The hall itself still exists. Unlike the music hall in Taylor, you could, I suppose, physically unlock the doors. But the whole point of hiring it, the entire purpose hosting this specific international summit, is now illegal. You can't legally do the thing the contract was for.
Exactly. So that's your argument. While physical performance, opening the doors, might seem possible, the legal performance of the contract's core purpose is impossible. This illegality, caused by the government action, makes the venture radically different from what was agreed.
So it strongly points towards government interference, like in Lim Kim Som.
I think that's the strongest argument, yes. The purpose is fundamentally undermined by the new law.
Okay, but we have to tackle those exceptions head on. What about foreseeability? Could the hall owner argue, well, everyone knew there were potential public health risks floating around, maybe even pandemic risks?
That's the most likely counterargument, invoking Davis and Ferrum. And this is where the analysis gets nuanced. You have to ask, was this specific law, banning this type of event with this timing, reasonably foreseeable when the contract was signed a year prior?
Knowing there's a general risk of, say, flea season is very different from foreseeing a specific government ban targeting international summits 6 months out.
Precisely. That's the distinction you'd argue. General background risks might be foreseeable, but the specific nature and impact of this legislative act probably weren't. Plus, crucially, this event makes performance illegal, which often weighs more heavily against foreseeability arguments than events just making things more expensive or difficult, like the shortages in Davis.
Right, so you'd argue the illegality aspect distinguishes it from Davis and makes the foreseeability argument weaker here.
That would be the line of reasoning, yes.
What about the other exceptions? Force majeure.
Well, the scenario doesn't say anything about a force majeure clause in their contract. So, based on the facts given, that rule doesn't seem applicable.
Okay. And self-induced.
Clearly not. Neither party caused the legislation, so that's off the table too.
So in the application, we're really digging in. We identify the likely category, government interference, link it to the facts, the law making the summit illegal, and then systematically knock down the potential counterarguments based on the exceptions, especially foreseeability.
Exactly. It's about building the case for frustration while actively addressing why the limitations don't apply on these specific facts.
Which brings us logically to the final step, conclusion.
Based on that analysis, applying the rules, weighing the arguments, particularly the strong illegality point against the foreseeability question, you state the most likely outcome,
Which would be?
that the contract is likely discharged by frustration. The supervening illegality caused by the government action appears to satisfy the requirements and isn't negated by the exceptions.
And you just reiterate the consequence.
Yes. State that if frustrated, the contract ends automatically from the date the law was passed, and the financial tidy-up would fall under the Frustrated Contracts Act.
Looking back, it really is a method, isn't it? Issue, rule, application, conclusion. It provides a clear structure for tackling what can feel like a complex mess of facts and law.
It really does. It forces you to be systematic, to identify the core question, lay out the relevant legal tools, apply them carefully to the facts, consider all angles including the exceptions, and then reach a reasoned judgment.
Okay, let's quickly recap the key takeaways from our deep dive today. We defined frustration, that supervening, unforeseen event, not your fault, making things impossible or radically different.
We looked at the main triggers. Destruction of the subject matter, Gaylor. Non-occurrence of a key event, Krell. Government interference, Lim Kim Som. And personal incapacity, Condor.
And just as important, when it doesn't apply. If the event was foreseeable, Davis, if a force majeure clause covers it, China Resources, or if you caused it yourself, Maritime National.
We also touched on the effects automatic discharge from the point of the event, and how the Frustrated Contracts Act helps sort out the money side more fairly than the old common law.
And crucially, we walked through how to use all that, applying the issue, rule, application, conclusion framework to that conference hall hypothetical, really focusing on analyzing the facts against the law, especially weighing things like illegality versus foreseeability.
Hopefully seeing that structured approach makes tackling these frustration problems feel a bit less daunting.
Happy studying! Until the next class.